go on? Go on, next case. Okay, the court will call on to be heard Cutlip versus Dorsey et al.
Good morning, may it please the court. My name is Tom Pycraft, and I have with me my associate, Michael Pelkowski. I represent...
20 minutes, and I put 5 on for rebuttal. Is that all right?
That's sufficient, Your Honor. Thank you.
Fire away.
I represent Patricia Cutlip, and this is a foreclosure issue. However...
Let me ask you this, just for starters, all right? Make sure that I got the facts straight. The mortgage that was recorded made reference to a contract for deed, which was also recorded, and it said which OR book and page it was recorded at, 1400, page 1117. So far, am I correct?
Correct.
Okay, so had a title researcher researched the title looking for the name Wilson, they would have found the mortgage, and the mortgage would have made reference to a recorded document, that being the contract for deed, where you would look for the legal description. Am I right so far?
Well, I mean, I assume that you're right from the standpoint that we never got to that point at the trial court level. Well, when we research titles,
you know it just as a matter of practice that we research titles using a name, right?
Sure.
Ms. Cutlip took title from Richard W. Wilson, right?
Correct.
So you would want to look at prior recorded information under the name of Richard W. Wilson, and you would find a mortgage that references a contract for deed, right?
Yes, but when you look to that contract for deed, the legal, what I think is still at issue...
Well, the mortgage doesn't contain a legal right. It only makes reference to another document, so you would have to look at the other document if you want to find out what the legal is, right?
Absolutely, and when you look at that...
Let me zero you in on my question, Tom.
Sure.
If you look at the contract for deed, you see a legal, that's a meets and bounds legal, right?
Correct.
And that clearly includes your client's property, right?
It's not the same legal description as my client's property, but... It
includes your client's property, though, right?
It would include my client's property.
And I mean, it doesn't even take an abstractor to figure that out. I mean, I'm not that good with these meets and bounds descriptions myself, but if you sit there with a diagram and you diagram it out, it starts at the same reference point, and it proceeds in the same direction, and reaches some point where the instruction is a little short, and so you basically got a smaller parcel in Ms. Cutlip's deed in, right?
That is correct.
Okay, so it really wasn't necessary to reform the mortgage because it already included your client's property, right?
I'm not trying to say that my client should not have done more than she did at the beginning.
I know that, but that wasn't the question. The reformation was an exercise that was unnecessary in this case because now there may have been other reasons for the reformation, but as it relates to your client, it was not necessary to reform the mortgage because your client's property was already included in the mortgage.
Yes, actually the mortgage, the legal description, by the time you get to the legal description, going all the way back, the legal description of the mortgage actually encumbered substantially more than it was supposed to encumber.
I mean, I ask you this because I'm sympathetic about some of your other arguments that
sure.
You weren't part of the Reformation proceeding, you shouldn't be bound by anything that went there. This trial judge erroneously relied on what happened in the Reformation proceeding, but after you plow through all of that,
sure,
you're still left with the fact that you had a mortgage on, your client had a mortgage on her property.
I understand that. My issue really stems from the very beginning where they never foreclosed on my client's property originally. So I don't believe that, as we raised as part of what you're talking about is the sympathetic facts, in that I don't believe that evidentiary here, because I guess what struck me as odd, obviously long before I got involved with the case, was this actually, on the original 3 parcels that they foreclosed on, there was actually a final judgment entered. And then they went back and had an evidentiary hearing to determine which property should have been covered by the mortgage. And at that point, my client, her property was not involved.
She wasn't involved.
She wasn't involved. The court didn't have subject matter jurisdiction over the property, and they didn't have personal jurisdiction over my client. So while we may...
But finally, they figured it out, and they did amend, and then they joined your client.
They did, but I was bound...
No mortgage foreclosure.
Right, but I was bound, the trial judge said I was bound by the order that was entered. I didn't even get to argue any of the additional issues at the trial.
One of the principles of appellate jurisprudence that we operate under is called the old tipsy coachman doctrine. You've heard of that, right?
I'm familiar with the tipsy coachman.
Even if the trial judge said the wrong thing, if the trial judge got to the right result, then we affirm.
I understand, but I'm not sure that, I understand in theory that my client's property may, I guess what the issue that is unresolved to me, going back to that evidentiary hearing, is if you read, now the evidentiary hearing transcript's rather lengthy, but if you read it, even the counsel that was representing the Dorseys at the time said, we screwed up the legal description, this could be read several different ways, we're not really sure which properties we were supposed, and he was the attorney that actually wrote the mortgage. And had we been there, had we been able to cross-examine, their key witness at that point, they had 2 main witnesses. They had the gentleman that originated the mortgage, and then they had a title expert who was also the brother of the attorney that was representing the Dorseys. And the mortgage originator indicated in his testimony that the properties that he mortgaged all had mobile homes on them. Then he recanted in his testimony down the line and said, well, the one that we released from the mortgage didn't have a mobile home on it.
Judge Torpy's question went to the issue of, that's a lot of chaff.
Yeah.
But at the end of the day, she didn't check title.
She didn't. And I understand that.
So the property that she bought was encumbered.
Well, it may have been encumbered, but I mean, I think...
And the argument is that that's a res judicata issue, is that correct? I mean, that issue has been resolved, has it not?
Well, I don't think that it has, because essentially what's come out...
Appeal before us?
Yeah, I mean, our basis is we shouldn't be bound by that determination, that order that happened prior to...
I accept that proposition, but I thought you told me that the contract for deed at 400-1117 encumbers your client's property.
It encumbered, yes, it encumbered a larger parcel.
Included your client.
But then yes. But what I'm saying is, had we been the determination that happened at this evidentiary hearing is which of these parcels did they actually intend to have the mortgage on? Because they didn't intend, even though I acknowledge it was recorded, they did not intend to mortgage, or they couldn't have. I don't believe Mr. Wilson even owned all of that larger piece of property at the time he did the mortgage. And had we been able to be part of that evidentiary hearing, we could have... They pretty much ignored my client's property at the evidentiary hearing. It comes up a couple of times, but really at the evidentiary hearing, Mr. Wilson had conveyed one of those parcels to his father, and that's what he was fighting to defend. So I don't even think we get...
Counselor, it seems like a lot of clutter here, and I want to go back.
Sure.
Your client's property was encumbered, is that correct?
She had, I don't, yes.
I just want to clarify that.
But I also, yes.
On April 11th of 2013, the record reflects that Dorsey filed an affidavit of indebtedness. What was he claiming that Mrs. Cutlip owed?
Nothing. Mr. Wilson...
Filed an affidavit of indebtedness, then. What in that affidavit of indebtedness, what was he claiming? Maybe it was an invalid claim, but what was he claiming?
He was claiming that Mr. Wilson had defaulted on the mortgage. and that Mr. Wilson had then transferred the loan, or I'm sorry, the property to my client.
So he was really claiming the amount of money that Wilson owed rather than Cutlip.
Yeah, my client, there's no dispute that my client doesn't owe the Dorseys any money.
The other issue that I wanted to ask you about is that you tell me that Ms. Cutlip may have had a BFP defense. What in the world facts would support a BFP defense in her situation? You represented to the court that you wanted to amend because to assert a you must have had some facts in mind that would have...
Yeah, we did.
allowed you to do that. What are they?
We felt by at the time, the information that we had, and we still believe that because my client obviously didn't have actual notice. The issue here is constructive or implied notice. And we believed that because of the legal description in the mortgage required you to reference the contract for deed, which then didn't have, it encumbered more than what the mortgage intended.
It's not a BFP defense.
We believed that it was, that we could at least raise facts.
You can't ask a judge to raise or to allow you to amend a complaint like that or an answer and raise that as an affirmative defense unless you believe that there are some facts that would support that BFP defense. And I frankly am at a loss to understand what facts you could possibly come up with that would support a BFP defense.
We didn't believe that she had notice at the time.
It's constructive notice. It's on the record. It's on the public records.
I understand, but the way that you had to, and I understand the court's position, I mean, but the way you had to go, you didn't end up at the same legal description that my client had. I thought there were enough of a difference there that we could have raised that issue had we been able to not be bound by that order from the evidentiary hearing. But, I mean, that's how we got here, is we didn't really get to argue anything other than the judge said, you're bound by that order, which I don't even think we get to where we are today. We don't even get to this foreclosure, but for the judge determining what happened at that evidentiary hearing when he didn't have jurisdiction to decide. I don't believe the court had jurisdiction to determine.
Well, your client obtained title from Richard W. Wilson.
She did.
Right. Aside from the mortgage, was it good title? Did Richard Wilson own the property?
He did.
Okay. Richard Wilson obtained title from Nicholas B. Rogers.
Correct.
Under the contract for deed.
Correct.
Right. So if your client has title to the property, it derived from the contract for deed recorded in OR Book 1400, page 1117. That's the derivation of title to your client, right?
Correct.
And it was in that same transaction between Nicholas B. Rogers and Richard W. Wilson that Mr. Wilson gave back a mortgage to Nicholas, right?
Oh, yes.
To Rogers, right?
Right, but this is a subsequent mortgage.
And then Dorsey got the mortgage from Rogers, right?
I don't believe that's what happened, Judge. I believe there was that was a separate transaction.
It
referenced it. That's where the issue came in.
Right.
That I believe our involvement could have had a different outcome in this case, is that this wasn't a purchase money, this wasn't related to that transaction. While they referenced that legal description, this was a separate mortgage that happened years after. I think that, if I remember correctly, the contract for deed was, I want to say it was 5 or 6 years prior to this, to the Dorsey's lending the money, something along those lines. And so I just do not believe that.
I thought you were getting at, I thought you were actually getting at something that.
Yeah, I don't.
What I thought you were getting at was that.
Sure.
When Richard Wilson gave that original mortgage to Nicholas B. Rogers, that those parties did not intend for the parcel that ultimately ended up in your client's hands to be included within that mortgage.
Yes, it's actually the the Dorsey mortgage, so not the Rogers mortgage. The contract for deed was a separate transaction.
Right.
That's how Mr. Wilson originally acquired the property. And then sometime later, and I don't know if the money that he borrowed from the Dorseys was to pay off the remainder of the contract for deed. I really don't know. We didn't get that far into the case to determine what he did with the money that he borrowed from the Dorseys, or if it was to develop the property. But at that point, I think there were eight. I think there were 8 parcels that were involved in the original amount. And, I mean, Judge Traynor even determined in his order after the evidentiary hearing that only 4 of them were intended to be mortgaged, including my client's property. That's why I say that even though the legal description was this bigger chunk of which my client's property was included, there was no dispute that they didn't intend the mortgage to cover all 8 of those properties. And had we been able to be part of that evidentiary hearing, we could have at least cross-examined or further explored what our client's risk was and all of that at that time. Thank you.
All right, thank you, sir. A little less than 5 minutes of rebuttal time.
Good morning. May it please the court, Reed Grimm on behalf of the Dorseys in this case. I think party names are probably a little bit easier based on the discussion before. Your Honors, this is a straightforward matter of title insurance, the record, and notice.
Well, you know, I don't understand why y'all went through the reformation. Your client did not.
Your Honor, I was not representing the Dorseys at the
Everybody
time.
always says that.
That's true in this case.
Your client did this reformation action. I mean, was there a purpose for that other than?
I think that was suggested by the trial judge, Judge Traynor, as a result of the evidentiary hearing. And where the evidentiary hearing came from in this case was that there was a dispute between Mr.
There
Wilson.
certainly wasn't any purpose for the reformation as it related to the Cutlip property, right?
No, sir, because in fact, as you focused on earlier, or one of the members of the panel did, there's no question here that the subject mortgage encumbers 8 acres, which includes the 1 acre parcel that Mr. Wilson subsequently conveyed to Ms. Cutlip. That is the record. That is what Mr. Wilson granted a mortgage to, or the property encumbered.
Mr. Grimm, he's right about some of his technical arguments. I mean, Cutlip can't be bound by a judgment in a prior action where she wasn't a party, right?
She cannot be bound by a judgment in which she was not a party. She can be bound by the encumbrance of the property that Mr. Wilson conveyed to her after encumbering it with a mortgage.
Right.
And that's the recording statute and...
Was it Judge Traynor that did the foreclosure that's up here on appeal now?
No, that was actually Senior Judge Hedstrom.
Yeah, so when the senior judge said that, you know, that the matter of the prior encumbrance had already been decided in that prior action, that was wrong, right?
Well, I think that if you take that statement in a vacuum,
Yeah,
you
well,
can...
I'm gonna, because that's the way it was presented to me in a vacuum.
Well, in the record, though, we have the...
I mean, it's wrong to say that any litigant is bound by some determination where that litigant never received notice and an opportunity to be heard, right?
It's wrong to say that a litigant is bound by the result of a proceeding in which they were not a party.
Right, but your argument is all of that doesn't make any difference because she still bought a piece of property that was mortgaged and your client owns and holds the mortgage and has a right to foreclose it, right?
That is my client's argument, Your Honor.
Okay, great. I think we understand it.
Do you need to hear more from me?
Say again?
Do you need to hear more from me?
While you're ahead.
I mean, it's straightforward. There, as the court identified earlier, I think it was referred to as chaff. There are other things that we can talk about that are attention-grabbing, but when you look at the Recording Act, when you look at the cases that the Supreme Court decided in the 30s, that's been the law of the state of Florida for 80 years, when you have a mortgage that encumbers a larger parcel of property, there is, and I would submit to the court that under the Supreme Court precedent, it's implied actual knowledge of what is either in the record or what an examination of the record would have disclosed, and it takes you to the mortgagee and it takes you to the mortgagor.
All right, sir, thank you.
Thank you, Your Honor.
All right, you got a little bit of time left, sir.
I think the reason that I think there is still an issue at the trial court level is that it's clear, certainly the notice issue is what it is, as far as what's recorded. The fact that Judge Traynor was able to determine at that evidentiary hearing that these parcels that were all technically encumbered by the recording weren't what was intended and weren't actually encumbered by the mortgage, that wasn't the party's initial intent, and that he removed some and added others, is why I think that it's material that we should have been part of that hearing. I understand that there is a chance that if the judge doesn't change his mind on that we end up bound by the recording, but I think there is still some possibility, if that wasn't one of the properties that was intended to be mortgaged, that there's still at least an argument to be made there. I understand my client can't testify she wasn't part of the initial contract. That's not what we're claiming. We're claiming we had a right to at least cross-examine the witnesses at that point.
Nor can any testimony vary an unambiguous legal description, right? I mean, the legal description is the meets and bounds description in the contract for deed is unambiguous, right?
Well, it said a portion or portions of is what the legal description in the mortgage said, and so the issue.
I'm talking about the legal in the contract for deed, OR Book 1400,
right.
Page 101.
And the one in the mortgage says a portion or portions of that legal description. It doesn't, I don't believe it says that exact legal description that was recorded in the
Counsel, I thought you conceded earlier that had she reviewed the record, she would have had notice. She would have had notice that her property was encumbered.
Well, she would have had notice to inquire, is what I mean, had she hired, certainly had she hired a title person, they would have at least, I don't know that they would have I don't know that we would have necessarily gotten to the point where them concluding that she was encumbered, but there's enough of a recording that she should have at least looked into it before she bought the property, if that makes.
Certainly enough in the record, though, to indicate she should have done something about it at the time of the closing.
I don't disagree with you, Your Honor. But I believe that it's not, that we could have, had we been part of that initial evidentiary hearing, at least been able to bear down on the issue of whether or not my client's property was intended. I understand what the recording says, but whether or not that was intended to be encumbered, because it's clear in hindsight now that some of it was not. So, that's all I have.
Okay, thank you for your arguments. The court will take a brief recess. As has been our custom in the past, we'll have coffee in the attorney's lounge, and if any of the attorneys would like to join us, please feel welcome to do so. The attorney's lounge is only for attorneys, though, not for your clients. Okay, thank you.